Law Simplified with Justice is anchored by Justice Maduforo. Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. We are well equipped in our litigation and advocacy for the benefit of our clients, corporates, and individuals. Why not visit us at 5 Oakfield House, Oakfield Road, Ilford, London, IG1 1EF. We are just 15 minutes from Liverpool Street Station. Tice Madox Solicitors. Try us. We are professional.
Hello, ladies and gentlemen. Welcome to another edition. My name is Justice Maduforo. I'm a solicitor of the Senior Court of England and Wales. I'm also a barrister solicitor of the Supreme Court of Nigeria. Tice Madox Solicitors is a 21st century law firm that ensures that you receive better representation at any stage of your proceedings or matter whatsoever. And that is why with this program coming, it is not a legal advice program, not. Therefore, whatever you hear me speak on this program or my discussant on this program, they are not legal advice. They are not. They are opinion. And under legal procedures and professionalism, you must not act on what you hear me speak on this program, but rather you have to book an appointment to come to the office and seek proper, tailor-made, custom-made legal advice that suits your circumstance at that time. So therefore, it's important you understand this. Ladies and gentlemen, on this program, I have brought in several topics and I've discussed several areas of law: immigration to family law, criminal, contract, employment law, litigations generally in the county court, high court, and going forward. I've discussed all that. And the essence is to educate you, to make sure that you are abreast with the law and your rights, and that you get justice, you get fairness in whatever stage of your proceedings or your matters. That's what this program is. It is to educate you, enlighten you, and ultimately ensure that you take action. Because if you are educated and you don't use it, or you are informed, you don't use it, and you sleep over it, then it will no longer be useful for you. The usefulness of what you hear is in the practicality of what you hear and you put into practice. Therefore, that's what this program is for, that you take action. You take action. Our telephone number on the screen, you call us and you book an appointment to come and see us in the office. If you want to see me in the office, you have to book an appointment to come and see me in the office. Ladies and gentlemen, you have to pay consultation fee when you come in. It is very reasonable. It's to ensure that all your circumstances take into account and you advise appropriately, ladies and gentlemen. Now, I have discussed certain areas of law, and today I'll be discussing immigration. And what is my topic today? I'll be discussing immigration, and my topic today is immigration update. Update on articulate of the ECHR or the Human Rights Act, vis-a-vis parent root, or vis-a-vis the residency of a child in this country. So in a short form, my topic today is immigration, and which is an update on articulate. Ladies and gentlemen, I have discussed this topic some time ago on this program, but because Article 8 is consistently and constantly evolving, which means Article 8 is constantly churned out there with very distinct and unique circumstances of individuals. Either the Home Office refusing that, then the First Track Tribunal will adjudicate on it, take into account and investigate the circumstances of that individual, on that basis make a judgment or make a decision whether or not that circumstance or the Article 8 of that individual is breached or not. Now, this topic also, as I said, will encompass the right of the parent whose child is a British citizen or whose child has remained in this country for 7 years. So, or the right of the child itself who is 7 years. So, which is why in totality, I kept this topic as an update on Article 8. Now, as I said, this topic or this particular avenue where applications are made to the Home Office and Home Office make decisions having taken into account on documentation provided and arguments put before it in that application and substantiating the claim, and Home Office making decision as to whether or not, yes, Article 8 will be breached if this individual's application is refused and required to leave the United Kingdom. The Home Office will decide whether it is in the interest of justice, public interest, or other criteria refused, or whether or not Article 8 family life is fulfilled or not met, fulfilled, not met, whatever the circumstance. The Home Office will take that decision having looked at the application, which is why I told you that some of you made this application to yourself. You are not in tune with the update. You are not in tune with the criteria for under family law, under the family life. You're not in tune under the Article 8, what is required, the ingredients required to substantiate Article 8. As I said earlier, Article 8 is constantly evolving. Flexibility in Article 8 means that it will constantly come afresh before the Home Office. Circumstances will come afresh before the first tier tribunal. Circumstances will come afresh before the upper tribunal. Circumstances will come afresh before, if an appeal to the Court of Appeal, all the way to the European Court of Justice or European Court of Justice of the European Union. A lot of circumstances will come before it. And these circumstances are completely unique at every single point in time. That's why I told you, and I keep saying this to you, that your circumstance with A, B, and C are never the same. You may have the same child like him, 7 years in this country, but your circumstances are never and can never be the same. That is why it is unique. Your term prints are unique to you alone. They can never match anybody else. Just like your DNA is unique, can never match anybody else. So therefore, your circumstances are also unique because you're a unique individual with unique circumstances. They're not the same. They might be similar, but definitely not the same. And similar in the sense of one or two ingredients, one or two areas meet that similarity, but they're not the same. And because they're not the same, the way they are viewed by the Home Office or by the First Tier Tribunal or Upper Tribunal, the tribunals in general, court in general, are not the same way they will view the other circumstance. So which is why I said to you, the update in Article 8 is consistently evolving, consistently changing. Either the court affirming certain new circumstances, infusing it to the already one that has been adjudicated upon by the competent jurisdiction of the courts, and then the new ones coming in place. Now, because Article 8 is so powerful, most of the times the Home Office, if you don't meet those tick box rules that will meet you under Article 8, you'll be refused. But not that you do not have the ingredients to Article 8, but simply because the tick box that's required to fulfill Article 8, as long as Home Office is concerned, you do not meet it at that initial preliminary stage. And on that basis, the application is refused. Now, that is what is consistently evolving. Each single day, the court is making decisions on Article 8. Now, as I said to you before, my discussion is in relation to Article 8 as it relates to family life of a parent to a child who is either a British citizen or whose word, a child, has remained in this country or has resided in this country for 7 years under the 7 years residency test. Or that in that circumstance, the individual himself have remained in this country for a number of time, obviously vis-a-vis private life now going forward. Now, the issue all taken into account, especially under Article 8, is to say, not the least, that Article 8 is constantly changing. Some of you hearing the sound of voice today, you may have made an application in the past under family life and it's been refused. Guess what? You need to come to Tice Madox Solicitors where we need to look at your circumstances. You see? We are very detailed in the sense that certain things other petitioners will overlook as not consequential. We don't overlook anything. We pick every pin on the floor to make sure that we add it up to make sense. And we search your mind and search your circumstance. We search your circumstance in detail, thorough, to see that they can at least make an reasonable argument that can stand the test of argument, stand the test of judicial scrutiny and judicial process. That is very crucial. And that is why this program comes to you, to educate you, to take action. If you're in the wrong place and you know it, because some of you know when you're in the wrong place. Some of you know when your applications are not going rightly. You will know. Some of you also will know that. Some of you also, even if you know the application is in the right place, you may want to take second opinion to make sure that you're in the right place. We are all here to serve you. We're all here to take that advice from you, instruction from you, and then advise you. Now, back to what I'm saying. Article 8 is consistently evolving. Courts of competent and higher jurisdictions are churning up circumstances and making decisions on that. I have discussed on this program, articulate, under the parent route, the correct approach. Now, this was a decision, recent decision, 2016 decision of the upper tribunal, and this decision was made not just by a single judge, by the president of the upper tribunal, as it stands, as it is at the moment, Honorable Justice McCloskey, and together with other senior upper tribunal judges. And this correct approach has now been ruled out, of which that most of the times the Home Office have applied the wrong criteria to assess either residency or articulate. So because they have failed to assess it properly, and that wrong practice has continued, some of you are beneficiary, or rather of those wrong errors, whereby it has been applied in the past by the Home Office or even by the tribunals in respect to whether or not you fulfill the requirement under the parent route through your child. Applications have been refused in the past. Even if I can tell you clearly, from the beginning, I have been a proponent on the fact that that approach has been wrong. But clearly, as I say, and which I am proud of, is that the upper tribunal has now laid down the correct approach in respect to assessment under proportionality, or under assessment of the residency and the parent route, which is the correct approach. Now, this is the correct approach which is just talked out by the, I said to you, the upper tribunal judge, McCloskey, Honorable Justice McCloskey. Now, it has been taken further. And that is the essence of this program today, this topic today, which is now update and articulate. The first correct approach by the Justice McCloskey, as I said earlier, was in 2016, early March or thereabout, 2016. Now, I am proud to tell you today as well, there is also a confirmation, a new decision, confirmation to that of the Justice McCloskey's decision, now taking it further to confirm it. No longer in the upper tribunal, but now in the Court of Appeal. You see, the Court of Appeal has higher jurisdiction over the upper tribunal. And if the Court of Appeal will now be able to confirm and will be able to redirect the minds of the Home Office, direct the minds of those who are making decision makers, to put the correct approach in proper perspective, and doesn't the previous stance taken by the Justice McCloskey of the upper tribunal. Having said that, that became the rule. Now, you see, I am very passionate when I talk about the law, because, and I know it is a very good instrument of social change, instrument to put happiness, make sure you're on the right path, especially in this country that obeys the law, this country that has great reliance on the law. And development has, over the years, that have been achieved as a result of the reliance on the law. And the law brings in achievements. The law brings in prosperity. The law brings in, yes, prosperity. Because if you have right to remain in this country and follow it the right way, you will prosper. You see, that's why it's important. Law is a complete change that holds the society together to make sure your success, not only yourself, your children, your grandchildren, grandparents, parents, everybody else in this country succeed. That's the law. That's why I'm passionate about it, to put it in a proper perspective to you, so you will understand the right way to key in and stay in the right way. Ladies and gentlemen, I'm discussing immigration, update and articulate. Update and articulate. As I said to you before, the previous best approach has been laid down, and correct approach by Justice McCloskey of the upper tribunal. And that was in March 2016 in the case of PD. Now the update today is that the Court of Appeal has taken it further and doesn't that, which means that not only is that upper tribunal decision now the right decision, but the Court of Appeal has further endorsed it as the best approach to take. Ladies and gentlemen, I'll take a very short break. When I return, I will continue with this update, what the Court of Appeal has finally said, and in terms of all its endorsement. Stay on there, don't change the dial. I remain Justice Maduforo, your preferred solicitor, and of course, preferred firm, Tice Madox Solicitors. Don't change the dial.
Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. Tice Madox Solicitors. Try us. We are professional.
Hello, ladies and gentlemen, and welcome back to the program. I remain your host, Justice Maduforo. I'm a solicitor of the Senior Court of England and Wales and also barrister and solicitor of the Supreme Court of Nigeria. I am politician and magistrate court duty solicitor of England and Wales, accredited, licensed by the legal agency, obviously through the Ministry of Justice, to provide independent legal advice to those of you at the police station, free of charge, all the way to the magistrate court, subject to means testing, all the way to the crown court and all other courts that you have, depending on the outcome of your case. So, ladies and gentlemen, I was discussing to you before I took a short break the new case law, which came recently, as a matter of fact, July 2016, from the Court of Appeal, from the stables of the Court of Appeal, in terms of the topic I brought to you today, which is that of the immigration update and articulate in respect to parents' root, in respect to child residency in this country. Now, what is that? Parent root. The parent root has been enshrined under the immigration rules, which basically means that the parent can apply to stay in this country as a result of the fact that he has subsisting and genuine relationship with the child who is either a British citizen and also who has resided in this country for 7 years period. And on that basis, okay, the application can be made. It's called parent root. Some of you obviously watching this program, Tice Madox Solicitors, have put a smile on your face, having successfully applied these applications and is granted. And you also will attest to testimony to that. Now, that is a route provided by the immigration rules, which changed in 2012 and upwards again towards 2014, all the changes in the policies and guidance of the Home Office as it relates to that application. Now, that is the parent route. Now, also, individuals themselves can also apply to stay in this country based on those who have resided here for 7 years, especially children. I'm talking about it now, who are resided in this country for 7 years. They are under the age of 17, and they've lived there for 7 years consistently without leaving the country. And then they are entitled to make this application themselves. See? So themselves. Now, because a child under 16 will certainly have a guidance, will not be allowed to be independent, or technically not independent. So that means that that child would definitely have the father, his mother, or guardian, whoever is looking after that child, to tag along with him or her. Now, the question which the court and the Home Office have consistently applied is on the basis of a caption, which is the reasonableness, and when it's unreasonable for that child to be required to leave, whether it's reasonable for the child to be required to leave the UK and return back to his country of origin, especially the child who has lived here for 7 years is not a British citizen. It's quite different to that of a British citizen when the child is already here and you're applying to stay in this country. So the different rules apply to that, but ultimately focusing on Section 55 of the Citizenship and Border Act, which obviously shows about the interest of the child to be the paramount consideration when applications are made on behalf of, decisions are made on behalf of children, especially not on behalf of children, where children are also involved. Ladies and gentlemen, so the update has gone further to either confirm, attain, and also to substantiate those errors which the Home Office have long past been implying and been implementing. Justice McCloskey in 2016 March put on a correct approach to that rule, which is the rule to parent root, and also the route which is intertwined with that of the 7 years residency of the child in this country. Some of you are sitting on an application about that you made in the past, which was refused, and Home Office has simply said that you are returning as a family unit back to your country. Therefore, it is reasonable for this child to go with you. Some of you received that letter. Some of you are sitting on that letter. Some of you are even trying to appeal on that letter. Some of you are appealing in that process. Some of you are waiting for decisions from the Home Office as to that application you've made through that. But I can tell you that you stand stronger to be positive on the positive outcome of your application when you come to Tice Madox Solicitors to make this application on your behalf, follow you through, and keep you updated, and put in all the requirements that is needed to make sure that application or that appeal succeed either in the first tribunal or upper tribunal. No matter the stage that you are appealing on, you may have given right of appeal in country and you're appealing that. Whatever that stage, You can count on Tice Madox Solicitors. You can count on me, Justice Maduforo. Very robust, very determined to ensure that you succeed, to make sure that your application sails smoothly, to make sure that you understand the chances of your application. Having said that, this new update came in. What is this new update? The Court of Appeals, as I said earlier, made that decision recently. It's a July 2016 decision by the Court of Appeal. And that decision is very crucial. It's an update on the parent rule, as I said. Also, making much more better emphasis on the 7-year residency of the child in this country. And because of the difficulty these days in immigration applications, because of the way the Home Office is squeezing and ensuring that applications are refused, even if it is reasonable to refuse it or not. Most applications that have come to me and from other places, people have come to me with refusal letters. It's very clear that having read the details and taken instructions, you see that one thing is clear. Either the representative who made the application did not argue properly to put forward the interest of their client, or to put forward the circumstances that will justify a grant, or that the Home Office, having the representative or whoever done it, the Home Office bluntly decided to refuse because of one clause or one line or one other place, one way or the other, the applicant has mixed it. So they refuse that. So 2 processes where these applications have been refused. But percentages have been refused by, equal percentage of those who have lodged these applications wrongly. And then equal percentage of the Home Office refusing it simply because of applying tick box approach to make decisions that relate to articulate. Tick box approach are not the right way to assess articulate. But they can only do so if you have immersed that application with much more credible and decisive and convincing argument. If there is no convincing argument and simply complete the form and just put finding closed, that is absolutely not the way to do it. And some of you that have transferred my cases to me, and when I look at presentations made on your behalf, and it's quite pathetic that no argument has been made properly. But I stand to either rectify this or stand to move into another option that may be helpful to you. But that will only be done when you come to my office and I seek proper instruction from you and then advise you the way forward to rectify any error that you may stand. So ladies and gentlemen, this is the Court of Appeal decision, and that's the Court of Appeal decision in the case of MA Pakistan. MA Pakistan is very important. So even if you read it, you may not understand to correlate it to the decision that was made earlier on, because that decision in MA Pakistan, the Court of Appeal rejected some of because it's MA Pakistan and others, which means that there are other people the cases were consolidated together, because cases can be consolidated so that if they are talking about the same issue, they can consolidate them as many as they are to make sure that these issues are dealt with in one hearing rather than having spaced hearings, so that the circumstances can be looked at and individual decisions made based on individual cases. So this is MA Pakistan and others, which fused in up to how many? 6 appellants in that case, 6 appellants. And so it's MA Pakistan and others. It's a 2016 decision, recently, as I said, July decision, and whereby the Court of Appeal went further to agree with Justice McCloskey in the correct approach which he took in determining, in assessing the reasonableness of a child who has resided in this country for 7 years to leave the UK or not. You see? Because we are thorough when I make applications on your behalf. I'm thorough when I decide your applications, when I look at the ingredients, take proper instruction from you. I will line it up with the status, with the case laws, with the statute, with the case law, with the guidance and policies that are changing, with arguments made in the past, present, future. I will consolidate them and produce a wonderful piece of argument whereby the Home Office themselves, even if they refuse that clearly will show that refusing that out of their instruction to refuse, not because you did not merit to be granted. But that is not the case. If it stops at that point in time, or that decision is made at that point in time, I will take it further to the next step in appeal. And I tell you this, 80% or 85% of cases of that nature has all succeeded in the tribunal, first or upper tribunal, or even to the upper tribunal, to the Court of Appeal, or under judicial review, simply because argument has been made sufficiently on your behalf. When we make that on your behalf, it succeeds. So this case law is crucial, which was trumped out recently, as I said to you, by the Court of Appeal George, obviously. This is led by Honorable Mr. Justice Nicole and others. This matter is very crucial. It dealt with matters of I beg your pardon. That was a court appeal decisions that was made, and then it came before Lord Justice Elias and 3 other of his friends, and who decided on this case in the court of appeal. And as I said, I follow these cases. I am keeping track on cases that will be useful to my clients. And because they're useful to my client, I keep track on the decisions. I keep track on them, both those I'm tracking and those I'm dealing with. I keep track on them. Informations are crucial for me to lift up, legal informations to argue your current matter. And that is why this program is to leading you to the right place where your case will be dealt with. Okay? That's very crucial. That's important. Okay? So you don't miss that. So this decision has come in, arguing properly in respect to how this case law will be followed. And that is what Justice Elias said, and he's agreed by his brothers in the court of appeal. 6 appeal applications, and where 2 of them were granted. Obviously, 4 were refused on that basis. But 2 that we are granted are very fundamental to this case. Okay? And that case went further to determine and discuss also Section 117B of the Immigration Act 2014. It has a flavor on it, and as I said, it immersed into it. So these are circumstances and areas whereby you need to understand the procedures and the processes, how they arrived, how the new case laws to assist you and assist you make a better application. Ladies and gentlemen, I'm discussing, and I've been discussing with you here, immigration update on articulate of the European Convention on Human Rights or Human Rights Act. The update there is through the new case law that I've chunked up by the Court of Appeal, which I mentioned to you, and the details are there. As I said to you, I only give you very limited and faint bullet point. You get the meat when you come to see me in the office. You get the full detail when I take full instruction from you. And then I will now immerse you and consider with the case law and present to you a bulletproof, watertight advice where you can run and you can rely on. Tice Madox Solicitors stand there to liberate you in the areas of family, employment, contract, criminal matters, litigations in the county court, in the employment tribunal, immigration tribunal. You want better representation. You want close eye on your case. You can count on us. Time is not on my side. I have to leave now, ladies and gentlemen. I remain your usual regular host, Justice Maduforo, and also I'm a solicitor. And this firm, Tice Madox Solicitors, check us on the web, check us on the details on the screen. Give us a call. Book an appointment to see me in the office. Remember, you have to pay consultation fee. It is reasonable and it's crucial. It's the foundation. It is the right thing to do. Until next time I come your way, I say your time has come.
Tice Madox Solicitors. Try us. We are professional.